Hi, thanks for using my court coach. I'm Sarah and I'll be your instructor today as we talk about contempts. What is a contempt? It is a quasi-criminal proceeding which can be used to enforce certain family law orders such as child support, spousal support, custody visitation orders, attorney fee orders, and property division orders that a party has violated. Um, how is a contempt proceeding initiated? There are certain mandatory forms that are required. In family law, you need to file and serve the FL 410, that's the order to show cause and affidavit for contempt, along with the applicable affidavit of facts constituting contempt, and that can be either your FL 411 or 412. We will have separate videos addressing how to fill out each of those forms. The affidavit of facts must specify and set forth the type of order violated, the date the order was issued, how the order was violated, and when the violation occurred. There are certain elements that must be proven in order for the court to find that a party is in contempt. There has to have been existence of a valid court order. So if an order has been voided, then it would not be considered a valid court order. The citee has to have knowledge of the order. And how is knowledge determined? Either they were personally served with a copy of the order and there's a proof of service on file attesting to that. They could have been present in court when the order was made. If it's a agreement that was signed by the parties, then their signature on the agreement would indicate that they are aware of the order. Or if they have previously sought relief related to the order, perhaps they filed a modification of support, and that's the order they're now claiming that they did not know about, then that would not hold much water. And then finally, the third element is you have to show willful disobedience of the order. In other words, they had the ability to comply but chose not to. This often comes up with support, that a party may not have the ability to comply with a support order. That would be a hard case to prove contempt in. Something to note, the contempt motion does have to be personally filed and served on the opposing party at least 21 days before the hearing. Service on the attorney will not suffice. And then finally, what sort of penalties can be issued with a finding of contempt? There can be mandatory community service or imprisonment, depending on the severity of the contempt, and if this is the first instance, the second instance, the third instance, etc. And there can be attorney fees and costs awarded to the party who prevails. So I hope you found this helpful. Good luck.